Let's focus first on arbitration. Arbitration, as I said, is a formal means of alternate dispute resolution. Arbitration has been used much more often in recent years than ever before. Now again, arbitration was once used primarily in collective bargaining situations. You may be familiar with Major League Baseball, for instance, in which a player wants more money and the parties are sent to arbitration. The player says, look, I've got the statistics to support this amount of salary. The team says, no, those statistics would only indicate this amount. And then it gets referred to arbitration, and the arbitrator will then pick a number. Maybe it's in the middle of those two. Maybe it'll be on one side or the other. But that's where many of you may have heard of arbitration before. The enforceability of the arbitration agreement is often litigated, meaning can this agreement be enforced? We said that ultimately enforcement is going to be based on contract principles. Therefore, if I can show that this arbitration agreement is not a valid contract, then I am not required to go through with its obligations. I can file my lawsuit in state or federal court. In this lecture, we know that employment agreements often include an arbitration clause. Often do, and again, increasingly used. And this arbitration clause will contain the scope of authority, meaning what can the arbitrator decide? Sometimes arbitrators are limited to only certain issues. Other times, arbitrators are given broad power, meaning they are given the power to decide all of the issues connected with the case, including something like, can the arbitrator be fair? If I want to make the argument that the arbitrator can't be fair, I have to bring that argument to the arbitrator. No court is going to look at it if in the agreement we say that the arbitrator gets to decide that. And so the scope of authority given to the arbitrator may be an issue because I may not even be able to raise my claim of unfairness because that's a question left up to the arbitrator. Now, arbitration is governed by statutes. The most important by far is the Federal Arbitration Act, often abbreviated as the FAA. The FAA governs most arbitrations. It governs how arbitrations are conducted and what is the meaning of arbitrations. The Federal Arbitration Act requires courts to enforce arbitration agreements and to enforce arbitration awards. Every state also has an Arbitration Act. However, if there is a dispute between what the state act says and the federal act says, the federal act applies. This is called the doctrine of preemption. And it says that because arbitration is so important to the federal government, if there's a dispute between a state Arbitration Act and a federal Arbitration Act, the federal arbitration argument will trump the state act. Arbitration looks a lot like a court case. It's adversarial, meaning there's going to be arguments made to a neutral third party or third parties. At an arbitration, the parties present evidence and witnesses just as they would in a trial. The only difference is the parties are essentially selecting the judge and jury. Oftentimes it's one person, one arbitrator gets to make all the calls. We also often see three arbitrators. Generally the plaintiff will choose one, the defendant will choose one, and then those two arbitrators will choose a third. And these arbitrators are going to be both the judge and the jury, meaning they're going to decide what law should apply, but they're also going to decide the facts of the case. Now, ordinarily, the rules of evidence are not important for arbitrations because rules of evidence are really based around the idea of a jury, what a jury can and cannot hear. And in the arbitration situation, the arbitrators can hear everything. And so we usually don't have rules of evidence in those cases. Parties end up in arbitration in different ways. Generally, the contract at issue, the employment agreement for instance, contains an agreement to arbitrate, an arbitration clause. But the parties may agree to arbitration after the dispute arises. The parties are always free to decide between themselves that arbitration may be a better means of resolving this dispute. Sometimes, rarely though, a court may order the parties to arbitration. That almost never happens. Courts will often order parties to mediation, but will almost never order parties to arbitration. As I said, arbitration is a binding procedure, meaning this neutral third party or parties is going to issue a decision, and that decision is going to bind the parties. There's going to be no appeal of an arbitration award. So on your test, you know these things, that if there's an arbitration agreement, the parties must arbitrate. And if there is an award, that's the final award. Even though, I may include facts that make it seem unfair or unlikely, nevertheless, the arbitration award is final. It binds the parties. The parties must abide by the award. There is no appeal to a higher arbitration panel or to a court. In fact, there is no appeal even if the parties agree to an appeal. In this case, Hall Street Associates versus Mattel, there was a dispute between a real estate developer and Mattel, the toy company, and the parties had in their contract an arbitration agreement. And the arbitration agreement said that if either party was unsatisfied with the result, they were then able to file a claim, a lawsuit in district court. That's what the parties agreed to. That's what the contract said. And in this case, the parties arbitrated their case, and Hall Street was not satisfied with the result. And so Hall Street filed a claim in district court. Mattel, even though they had signed an agreement saying either party could appeal, at the appellate court level they say, or at the trial court level they say, this is governed by arbitration. Arbitration applies. And this is a case that goes all the way to the Supreme Court, because the Supreme Court is kind of torn between this idea of, well, we got to respect what the parties contracted to, and we know that arbitration is final and non-appealable. Well, the court in the end sided with that second argument that said even if the parties agree to an appeal, there is no appeal. So again, look for a problem like that on your test, because we know that there's no appeal. And the reasoning behind that is solid, because what the Supreme Court essentially said was, we don't want to turn trial courts, U.S. district courts, into arbitration appeal courts. And so we eliminate the possibility of that happening by saying, if there's an arbitration award, it must be enforced.